Gary in any place in the piece or out of it defend Mel Gibson or Alec Baldwin. I have looked at the Playboy interview a few times now. I am unaware, as I have seen reported, of Gary Oldman defending any anti-Semitic remarks in the interview, or for that matter, any place. He would not do so, and in fact, he finds any kind of bigotry, homophobia, anti-Semitism, racism, or sexism unacceptable and disgraceful, period. If you read the Playboy piece correctly and entirely and in context, it is the hypocrisy of political correctness that Gary is addressing, nothing else. And that is, of course, true. If you talk, Harvey Weinstein would say about Jews significantly worse things than Gary Oldman says about Jews. I'm still struggling to find out exactly what Gary Oldman said that was so terrible about Jews. He's saying that Jews went after Mel Gibson. Some of the people who went after Mel Gibson were Jews. Some were not Jews. Some of that was justified. But if he's pointing out a double standard, he's exactly right. There is a double standard. Depending on who you are and what you say in Hollywood, you get away with it. And on that, Gary Oldman is exactly correct. He's exactly correct. Oldman said in that interview, quote, "There are a number of people who speak truth in this culture." He said, "A voice I particularly like is Charles Krauthammer." There's that crazy anti-Semite, Gary Oldman, ripping into Jew Charles Krauthammer by saying that he thinks, quote, "He's incredibly smart. I think he's fair, very savvy, and politically insightful, so I enjoy watching him." All the anti-Semites I know love Charles Krauthammer. Love him. Hollywood only gets upset when a conservative speaks out. They never get upset when a leftist expresses bigotry. When Spike Lee, who has a new movie coming out, says that he stares daggers at interracial couples, everybody shrugs, oh, that's just Spike. When Gary Oldman says there's a double standard with regard to the treatment of Mel Gibson and Spike Lee, they go after Gary Oldman hammer and tongs. Absolute silliness. Well, in more local news, the Port of Seattle has now proposed a $15.50 total compensation airport wage by 2017 with a $13 cash minimum. Port of Seattle Commissioner Courtney Gregoire proposed at today's meeting, quote, "A total compensation minimum wage for SeaTac airport employees. Minimum total compensation would begin at $13.72 an hour in 2015. Minimum cash wage of $11.22. It would rise to $15.50 an hour in 2017. How does that compare to the Seattle minimum wage? It depends who you work for, according to horsesass.org. The commissioner's proposal gets airport workers to higher wage and minimum compensation levels faster than Seattle workers at businesses with 500 or fewer employees, if you're a small business. But in the long run, it pays airport workers less than they would earn at a minimum wage job in Seattle. Interestingly, a lot of folks are saying that they have security concerns and they want to make sure that they have a less high turnover rate over at SeaTac. San Francisco International Airport apparently had similar job turnover issues before instituting its highest in the nation airport minimum wage. The turnover rate has now been reduced from 110% a year to 25% a year. Right, and they're paying a lot more money. So, shocker. The continuing fallout from the Seattle $15 minimum wage it's going to spread. All it's really going to do is inflate prices, increase rents, and then, of course, we'll see the Seattle city government, and we'll see the airport and all the areas around the airport increase their rent, and then they'll have to sponsor all of this. They will have to sponsor all of this new housing to make sure that people can afford to live there. They'll have to pass subsidies to allow people to afford food. You can't artificially boost wages. Wages are what they are. If the Port of Seattle wants to make sure that people don't leave, it will pay them more. If not, it won't. Now, coming up tomorrow night, actually, boy, that's happened fast. Tomorrow night, June 26th, over at Seattle U, we will be having the big debate. We've been talking about it for weeks here on the Ben Shapiro Show and on KTTH. The big debate about whether religious freedom is being quashed in the country. The timing could not be better. The Hobby Lobby case is about to come up before the Supreme Court. They're about to release their decision. That should happen either tomorrow or Friday. That is the case in which the Supreme Court will decide whether Obamacare can force you as a religious person to violate your own religious precepts and purchase contraceptives or abortion for somebody. Our big debate is going to feature me, Michael Medved, David Bose, as well as some folks from the other side, including a Huffington Post columnist, a UW professor, and Reverend Monica Corsero from Rainier Beach Methodist. She's the woman behind the gay Boy Scout leader. Should be a fascinating, interesting debate. $15. $15 to go. $10 if you're a student. Tickets are running out fast, so go to kTTH.com right now, kTTH.com right now, and make sure that you get your tickets. Can't wait to see you tomorrow night. As we continue here on the Ben Shapiro Show, huge decision comes down from the Supreme Court. We'll talk about it. Ben Shapiro Show, AM 770, KTTH, kTTH.com. Big decision comes down from the Supreme Court today. They've now ruled that police cannot snoop through your cell phone after they arrest you. It was a unanimous decision, not a close decision. And the reason this is important is because it has ramifications for the National Security Agency and whether they are allowed to surveil you. Basically, here's the decision. Police agencies, according to the Washington Times, who had arrested people, had argued that searching through the data on their cell phones was no different than asking somebody to turn out their pockets. The justices rejected that. They said that a cell phone is slightly more fundamental than that. This is an update to privacy rights. Chief Justice John Roberts wrote, quote, "The fact that technology now allows an individual to carry such information in his hand does not make the information any less worthy of the protection for which the founders fought. Our answer to the question of what police must do before searching a cell phone seized incident to an arrest is accordingly simple. Get a warrant." Justices said police cannot even check a cell phone's call log without a warrant, saying that even those contain more information than just phone numbers. And so perusing them is a violation of privacy that can only be justified with a warrant. Here's the situation. You're walking down the street, and this case actually arose. This is what happened. A guy was driving, and turned out that he was driving without a license. So they searched him, and they found his cell phone. They proceeded to scroll through his cell phone. They found he'd been related to some gang-linked crimes. He sued, and he said, hold on a second. You can't do that. You can't search my phone just because you pulled me over. And the Supreme Court said that's exactly right, because you carry around your phone, and that has all your records in it, all your emails, all of your phone calls. You'd have to have a warrant for that in any other situation. Just because the police pulled you over in a car doesn't mean that the police would be able to, for example, go into your house, break open your phone book, and start reading through it. They wouldn't be able to go get those old love letters you have from high school just because they arrested you in an unrelated sting. They'd have to go get a warrant, a search warrant. The Chief Justice said that cell phones are different because people can carry around only so much more data, the equivalent of millions of pages of documents that police would have access to, but that the data itself is qualitatively different than what someone might otherwise carry. He said it can lay down your entire history, from your medical records to specific movements down to the minute. The Chief Justice cited precedent that said there's a difference between asking somebody to turn out their pockets, which the design of that is to prevent them from using weaponry against the police, and ransacking his house for everything which may incriminate him. The other question is whether the data is actually stored. The Obama administration and the state of California, which both wanted to justify cell phone searches, they said that remotely stored data couldn't be searched. So in other words, if you have an email address, they can't just sign into your email address using your phone. But Chief Justice Roberts said that even if it's stored on your phone, the distinction is just too fuzzy. The court carved out exceptions for exigencies that arise, such as major security threats. So let's say that you're in the middle of searching for somebody who may be trying to set off a nuclear bomb. You can grab his phone. But this has some pretty real ramifications. Some pretty significant ramifications, actually, for the NSA program. Why in the world would we be allowed to search my email addresses, to search my phone, to search anything that I own when I haven't even been arrested? In other words, if you arrest me, you can't search my phone, but if you don't arrest me, you can? What did I do that merits that sort of treatment? Don't I have the protections of the Fourth Amendment to the Constitution of the United States? And yet, the Obama administration claims that despite the fact that there is no urgent threat of terrorism, right, Al-Qaeda's on the run, that they have the ability to search everything that I ever did on my phone, on my computer. They can search my metadata. They can find out where I was, who I was talking to, when that happened. They have the ability to search the content of my emails. They say they don't do it, but sorry if I don't trust a government that discriminates against all these various conservative groups. So big decision from the Supreme Court with some pretty wide-ranging ramifications. There's a second decision that came down that's going to affect people who use Arrow. That's an internet service that allows customers to watch broadcast TV programs on mobile devices. It was launched a year ago in New York. It extended to 10 other cities. It allowed customers to watch over-the-air TV programs on a smartphone, tablet, or computer for just $8 a month. You could view them live or record them for later viewing. The court found that Arrow violates federal copyright law by retransmitting copyrighted programs without paying a copyright fee. Arrow's founder and CEO said that the ruling is, quote, a massive setback for the American consumer. Barry Diller is a major backer of the service, and he told CNBC, "We tried, but it's over, gang." NBC Universal was among the challengers, so is Walt Disney. Justice Breyer was writing for the majority. He stressed that it was a limited decision. It shouldn't discourage the emergence or use of different kinds of technologies. There had been contradictory rulings on Arrow's legality. The question was whether this was a copyright violation. It was a violation of the public performance of copyrighted works. The law regulates the transmission of a TV program, quote, to the public by any means or device or process, whether the members of the public capable of receiving the performance or display receive it in the same place or in separate places and at the same time or at different times. Arrow argued it was not covered by the law because all of its various users had an individual antenna, and a signal was sent to a sector of a video recorder dedicated to that choice and then streamed. So they said it wasn't a public performance. Even if thousands of users were watching the same program, it was really thousands of individual performances. The Supreme Court ruled differently. The Supreme Court said that company now has to be shut down. Basically, it's a violation of copyright law. The big decision that we're waiting for this week is not that one, and it's not the police one. The big decision that we're waiting for this week, which didn't happen, is the decision on Hobby Lobby. And the Hobby Lobby case is, of course, the case in which the Christian-owned company has challenged the ability of the federal government to force them to pay for the contraceptive care for their employees in violation of their religious sensibilities. Now, Obamacare does allow, if you're a quote-unquote religious institution, it allows you to not cover that sort of stuff. But the truth is that anybody who's religious knows how useless that is. Anybody who's religious understands. Your religion permeates your life. It acts on you day to day. It's not something that just stops when you leave church. And if the Supreme Court is to declare that Obamacare trumps your right to free exercise of religion, then essentially, we've now come to the point in American life where religion is relegated to not even